state and this is in that state, then you're audible, but you sound further away because you're.
So by my clock, it is 6 o'clock, and I just wanted to confirm again that the room at the Kalapuya building can hear me.
We hear you, Chair.
Well, thank you. And just as a heads up, because I am virtual, after I call roll and confirm that we've established a quorum, I would like to invite a motion to appoint a chair pro tem, someone in the room who could conduct the meeting, because it would obviously be pretty awkward if I'm conducting the meeting remotely. But I will call this meeting to order and begin with a roll call. Commissioner Bisco.
Present.
Commissioner Cash. I don't see her online either. Commissioner Fulford.
Here.
Commissioner Lee.
Here.
Commissioner Struthers.
Here.
Commissioner Toulos, and I apologize, this is the first time I've tried to pronounce your name, so if I have it incorrect, please correct me.
I'm here. It's Tullis, but
Tullis, okay. Thank you very much. Commissioner Wilson.
Here.
Vice Chair Heyman.
Present.
Excellent. Okay, I will record for the record that we do have a valid quorum. And as presaged, I would like to entertain a motion to nominate a chair pro tem from the folks in the room.
Chair Fowler, I'll move to nominate Commissioner Struthers as the chair pro tem for tonight's meeting.
Do we have a second?
Second.
Thank you. Any discussion before I call for the vote? I believe we can do this by voice vote. All those in favor signify by aye.
Aye.
Aye. Any opposed? Thank you. Commissioner Struthers, I hand the virtual gavel to you.
Thank you, Chair Fowler. Good evening, everyone. First item on our agenda tonight is approval of minutes from June 16th, 2026. They were in our meeting packet that was provided to us. Do I have a motion to approve those minutes?
I would make a motion to approve.
Thank you. Is there a second?
Second.
Thank you. So the motion was by Vice Chair Heyman and seconded by Commissioner Fulford. Is there any discussion on the minutes from June 16th? Seeing no discussion, we'll go to vote. All those in favor of approving the minutes from June 16th signify by saying aye.
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 All those opposed say no. Minutes are approved. We have nothing on the consent calendar. However, I'm going to take my prerogative as chair tonight for us to do quick introductions with our newest member, Desiree. Can you please say your last name one more time for me?
Tullis, like the airport Dulles.
Oh, Dulles.
Yes, but it's
So we'll just, if we can real quick, go around, we'll do our names, what part of the county we live in, and then anything else anybody wants to share. So I'll start. I'm Andrew Struthers. I am been on the Planning Commission, I believe now 4 years or almost going on 4 years, and I live here in the city of Corvallis. We'll go to my left here.
Hi, Commissioner Tullis. My name is Ed Fulford, Commissioner Fulford. I represent Corvallis and been a commissioner for about 3 years.
My name is Evelyn Lee. I'm from the South Benton County area. I live between Monroe and Alpine out in the rural area. And I've been on the commission more than 4 years, I think, because I stepped into an incomplete term, and then I started another one. I should look that up because I don't really remember. Nice to meet you.
We've met. I'm Bob Richardson, the Community Development Director.
And we'll keep going around with our current members if we can, but
So Catherine Bisco, welcome. I am, been on the commission, so this will be my 4th year also. And Cindy Paloma is where I'm from.
And I'm John Wilson, and I'm in my 3rd year or 4th year. I can never count those years, but I'm in Adair Village and I represent North Benton County.
and then online, Chair Fowler.
Good evening, Nick Fowler, and I'm the literal and figurative graybeard of the group, as that I've been on the commission, I think, 8 years now. And I live in a resource zone, exclusive farm property in North Benton County.
And then Vice Chair Hammond.
Hi, I'm Greg Heyman and I live in North Albany. And I've been on, I think, the Planning Commission 3 years, somewhere around that.
And then I would invite our newest commissioner, if there's anything you want to introduce yourself and provide any information about you joining our commission here.
Well, good evening, everyone. My name is Desiree Tillis, and it's my first meeting. I'm in Corvallis in the Woodland Hill area.
Wonderful. All right, we will get to the meat of our meeting tonight. So tonight we are reviewing the land use application LU 26015. The planning official denied this application. The applicant appealed the decision in a timely manner. This is a de novo public hearing. The commission will review the record below and may consider relevant new testimony and evidence. Any person may appear and be heard. The commission may affirm, reverse, or modify the decision in whole or in part and must adopt findings supporting its decision. Although the appeal notice identifies the appellant's objections, the commission may decide whether the application satisfies all applicable approval criteria, not merely whether the appellant was shown, I should have practiced reading the script here, whether the appellant has shown error. Testimony, argument, and evidence should therefore address the applicable criteria and issue them and the issues material to them. Because this is a quasi-judicial matter, each commissioner must disclose any actual or potential conflict of interest, any facts that could reasonably bear on impartiality, and any ex parte contact, including site visits or communications outside this hearing concerning this application or appeal. A commissioner who has a disclosure should describe its substance now without disclosing privileged legal advice. Does any commissioner have a conflict, bias, concern, or ex parte contact to disclose? I'm seeing no's all the way across, and I have none either. Does any participant wish to challenge a commissioner's qualification to participate based on conflict, bias, or ex parte contact? Please state that bias with specificity. And I am not seeing any. The applicable substantive criteria are BCC 60.108, ORS 215.750, OAR 660-006, BCC 60.405 through 60.410, and BCC Chapter 99. Testimony, arguments, and evidence must be directed to these criteria or to other criteria in the Benton County Comprehensive Plan or Development Code that you believe apply. If you rely on other criterion, identify it by criterion and explain why it applies. Failure to raise an issue accompanied by statement or evidence sufficient to give the commission and the parties an opportunity to respond precludes an appeal to the Land Use Board of Appeals based on that issue. Please distinguish facts and evidence from legal arguments where possible. The applicant retains the burden to demonstrate compliance with the applicable approval criteria. The commission's decision must be based on the record and supported by findings connecting the criteria, the facts relied upon, and the decision. Hearing procedures. The order of presentation will be applicants. Do we not normally do staff presentation first? So
Yeah, I think-
the order of presentation will be staff presentation, then the applicant, other persons in favor, persons in opposition, beginning with the appellant if the appellant is different from the applicant, governmental bodies, and applicant rebuttal. Rebuttal is limited to matters raised in opposition testimony or by governmental bodies. The time limits will be, will be 3 minutes for persons speaking in favor or opposition. A speaker may not transfer time unless the chair allows it under a rule applied equally. Please begin by stating your name and mailing address, or provide the address in writing to staff if you do not wish to state it out loud. Direct comments to the commission, avoid repetition, and identify any document or demonstration exhibit you offer. Questions from commissioners are not counted against the speaker's time. The chair may allow a focused response from another party when needed for a fair and intelligible record. That is the script. So we will then move on to the staff presentation, and I would invite any staff who are present to begin that.
And so that's me. My name is Bob Richardson, Community Development Director. Thank you for the time that we've made. I'm going to invite Russell Barlow to join me. Russell is the Benton County GIS coordinator and was part of the analysis and development of the which you'll see before you tonight in terms of analysis. I do want to start by saying that that I'm going to hop around a little bit with these slides, but I think we'll get to the main points and kind of keep this at a high level, at least to start with, and then try, if there's detailed questions, we'll do our best to answer those, and go from there. So to begin, I think as you mentioned, Commissioner Struthers, that
Hey, just a second. I do.
only the decision to, regarding the template test, or are we looking at any other aspect of the application?
Really, the appeal issue is the template test and the ability to establish a dwelling right. For example, if the planning commission were to approve the dwelling right, then there would still be other development standards and siting standards that would apply to the project.
So for the purposes of our hearing tonight, we're just looking at the template test?
Yes.
Thank you.
Commissioner Wolf?
Thank you, Chair Pro Tem. Well, I have a couple of Scrivener's questions in the report. There is on table, okay, and I'm assuming these are just Scrivener's errors. Table 1 has a lot that ends in 0300, and there are 2 of those. So I know that there's, I double checked. It indicates there's a dwelling that was on that property in 1920, but in table 4, where that same lot number is listed, it lists no dwelling. So I didn't know which one was correct. I just want to clarify that from the staff report. And I don't necessarily need an answer right now, but if that's something that just needs to be corrected, that would be helpful. The other one is, there's a reference to the property being both east and west in the staff report. And I didn't know if that was just, again, another Scrivener's error in terms of, because I think it's at the beginning where it lists the initial property. The vacant lot is located west of a property located at, and I think later in the report it lists it as being east. Yeah, on page, on attachment C1, page 1, it lists the property is located east of that address. So that was the only other Scrivener, I think. And then, well, and my only question was, there was an asterisk or a footnote reference to one of the properties. It says 2007, but it's being referenced as a replacement dwelling from 1992. So I'm assuming the asterisk is not for a footnote, but just that the explanation of the asterisk is that replacement.
I'm sorry.
No, it's okay. I know I'm going quickly. I'm just, I can, and so I'm just trying to clarify, because I just want to make sure that that the items in the staff report just were consistent in terms of what we've been presented with. And then the only other question I have is that you have talked about how the county has done template tests in the past. And in order to do this one, you reached out to the standard that Benton County's used, and then you went to Jackson County standard, and then the DLCD standard. In previous template test applications, is that consistent with previous template test applications?
Okay, so I'm going to say I've not previously provided analysis of template tests and any other applications, but I can't speak to that in much detail.
Sure.
Also, they're not standards, so there's not a prescribed standard for the way to do this. But
for the alignment.
Yes,
for the alignment issue.
So what happened was planning staff looked at it and said, okay, this is how we typically evaluate these things, and put a template on there and looked at it, and it did result in 11 parcels being encompassed. And so in conversations with the applicant was encouraging us, like, look, there's another way to do this, think about it this way or that way. And so we continued to explore other options, which prompted the call to the Department of Land Conservation and Development to say, this is how we're doing it. Does this make sense to you? Do you have any guidance? And they provided some feedback that caused planning staff to change slightly how they were how the analysis was created, the methodology for determining the alignment of the template. And then in addition to that, it was just sort of like a additional research. Well, how does somebody else do it? And so we found out that Jackson County had a way that was at least accepted or discussed as a good way at state level. And so we tried that method. So it was we probably wouldn't have gone through those 2 other steps if the applicant hadn't encouraged us to explore that further. And yeah, even when we did, we still didn't result in the same parcel, 11 parcel county.
Oh, okay. And this is an awkward. I mean, the question, I guess what I'm asking, because what I'm reading into this is that we're trying to apply a rational standard to the template test for both Benton County and I suppose in compliance with the ORS and our county code. But if the commission were to overturn the staff decision, does that set a new precedent for the template test?
I would argue that it does not set a precedent.
Okay.
And perhaps if you were to go that way, I might even ask that you make such a statement. I think to set a precedent, it would have to be something where the exact same set of facts would apply in over and over and over again.
Okay.
To really be like, oh, that's the precedent. I think that what we will do at a staff level, maybe regardless of the planning commission decision, is that we would take the approach that we've arrived at and turn that into an administrative policy that we would share with future applicants to say, this is how we will apply the review criteria. And this is the method.
And the only reason I ask is that I thought I read in the applicant's appeal that there was a and I don't know if I can find it right away, but that they had indicated in their appeal that they felt that that the staff was writing into code or writing code with regards to their decision making about the template test that just wasn't there in the code. So this is just an opportunity for you, I guess, to respond to that.
Staff is not writing code.
Right.
What we are trying to do is to look at an application and just sort of stand back and say, how do we determine when something is aligned to the maximum extent possible with a road? We asked ourselves that question. The answer led us to a certain methodology. And it's a method that can be reproduced. And I'll be careful not to get into argument with the applicant and their approach, but it's something that we think we can apply to other future cases. And I don't think that we can take their particular method and replicate that over and over again. And so that's one of the big differences. Perhaps Russ, you had something you want to add?
Yeah, I focused a lot on reproducibility when I was going through the process. And so it's pretty well laid out. Anybody could follow it. And I received, I came in after the appeal, so I saw the method that the applicant was using. And really the only issue that I had with reproducing theirs was I could make the line that they had made, but I couldn't, given the points that they provided, the 3 points on the road, but I couldn't figure out how to get those points. There wasn't, I didn't see a process for picking where in the spurt of the road that it was, the line was, or the point was. And that's where I think that the reproducibility falls short is if somebody were to take the same process, I think it'd be very easy to get a completely different answer for what is the predominant on the road. And then with the process that I used here, I think that anybody that had a basic GIS understanding could follow conceptually and through the actual steps to arrive at the same one, regardless of how the road is shaped or anything like that. The same process for finding centrally, finding all those parts is always the same.
And so it breaks down to the staff's methodology broke the road up into 25 segments
250, it was 25-foot section.
or 25-foot sections.
I think it ended up being just a hair over a mile, just shy of 6,000 feet.
Okay.
And then we took that and we broke it up into 25-foot sections. The original staff process, I used something called densifying, where we could make it 25 feet. The original staff process was just using the vertexes as the road presented them, as it was curvilinear. And so there's more consistency there. And that was 107 vertexes, I think. And so we split it up into many smaller bits to get the vectors.
Okay.
And so I think the number was 250.
So out of if I understand correctly, we're looking at 4 methodologies, 3 of which were developed by the staff in order to arrive at make a template test determination for the parcel. And then the 4th one is the applicant's methodology, which is or isn't reproducible at this point for any other circumstance, at least as if I understand you correctly.
Yeah.
Okay.
I wasn't able to get this out.
Okay.
I did too. Sure.
My time.
Okay,
Are
Commissioner-
questions to
Yep.
what's been said or questions as in? Okay. Yes, I have a couple questions about timing and procedure a little bit as it relates to this application. So as I read our packet, I see that on March 18th, 2026, the department received an application for the template test to authorize the placement of a dwelling. The department deemed the application incomplete on March 31st, and the application was deemed complete on April 13th. I'm curious if during that period of time of completing the application, at any point was any of the methodologies that the county used to determine the maximum extent possible, was that presented to the applicant as, maybe let me step back for a moment. When did you do the testing using DLCD's recommendations, Jackson County's methodology, and what had been done historically by Benton County? Was it before, during, or after this completion of application process?
It's hard for me to answer that because I wasn't the person that did that work. It was our associate planner, James Wright, who's on leave now.
Okay.
So there was communication between he and the applicant over that period of time. And at least before the staff report was also that information would have been communicated to the applicant. I'm not sure in what level of detail. The applicant will probably be able to tell you what their perspective on that is. And after the appeal came in, they had other conversations with the applicant where we shared information back and forth, both them to staff and county staff back to them. So that's what I can say. I don't know the exact dates. I'm sorry.
Okay. So then
I think that I could say though that from the beginning, I believe the applicant would probably agree with this. The staff was informing the applicant that we didn't believe that their application met the review criteria. And that was from the very beginning. I think that's one of the concerns the applicant had. Was that the approach that they proposed, we said from the get-go, we didn't think that was going to result in satisfying review criteria. So those conversations were going on from what they call a statement.
okay. Is it possible to go back to the map on the slide deck that we had there that showed the orientation of the road? I just want to clarify that what I'm seeing is what I'm understanding also.
I have an exhibit that has all of them.
Okay, that might be helpful. So if you can go back to keep going. I think it's the one with the trees on it.
Great. So this was the.
Yep, not those. Go back to it's a one with the trees. It actually shows like the satellite view. Keep going. It's a single slide. Oh, it must not be back. Is that all? What am I missing then? There's one missing.
Was it that one?
Nope, keep going. Nope, nope. If you can keep going all the way to the end, then I'll just make sure. It's none of those per se. It's one of the ones with the road on it.
Yeah,
That this one has the road on it.
Okay,
Yeah,
but
that one
it
has the
also
road.
had, is this the last one, Bob? That's the last one.
So
Okay, so if we go back to that one, I just want to clarify then, the thing that looks like a question mark almost, if it had a curly Q on that front end, and that's Marys River Road, right? I mean, it's marked that way. I just want to make sure.
This road comes through,
Correct.
and then this gray area is the
Parcel.
parcel I'm looking at. That's the central. And this is right template. That's the island template.
And
And these are the two that are in.
would you mind going back again? So the gray area is the 97 acres we're talking about?
Right here,
Yes.
that is the parcel we're talking about.
Okay. So part of my question is maybe a mathematical question or how we calculated or evaluated is we have a road that this property does not run along. It's not the entirety of that road, right? So when we were asking about the maximum extent possible and we are using the conversations of aligning with the road, if we took, you said roughly, I think you said 250 points.
If we broke up some.
205, I think.
We split out the road from here. So if we took like this chunk of road, we split it up into 25-foot sections. And then we took the
Right.
angle of that.
Bearing.
So we're taking the property and we're trying to align it to the entirety of Marys River Road then, or the entirety of that section
Not
of.
the property, just the town.
Which is that rectangle.
Correct.
Yeah, it goes to the
Yeah.
template.
Okay,
So that's the prescribed.
But-
The two
Right.
that we're holding consistent is the centroid of the two things. So it's like we took a pin and we pinned both. of
yep,
them,
got that.
And then we spun the road of the template.
Okay. So I might have an additional question there. That's helpful. So let me just ask this question. So as I'm reading in this document, my first question is there are several, excuse me. If the Benton County Code does not prescribe specifically how we do this, right? And that if I'm hearing that correctly, how would we anticipate an applicant to know how explicitly we do this? And how would we give them the tools to come with whether it was the completed issues or not, and it may not be, but how would we expect them to determine whether or not they even could make this work? What they did, by the sounds of before we hear it from testimony, but from this record, the staff report, what I'm understanding is that they did in fact bring forward a space that had 11 dwellings within that what did you call it? Centroid, right? It's the centroid. Okay, that's a new word. In our staff report, we have page 6 of 8, for example, it's the second paragraph. While staff were able to reproduce the applicant's final parcel count using their stated orientation, and then it goes on to your analysis, but staff has concluded even in this report that yes, we were able to reproduce their final parcel count. If we don't have Benton County Code actually explicitly saying this is how we do a test template like this, well, first I'm going to say there's an area that maybe we should fix as we look at our code, but we are asking for them to comply with something that isn't actually in our code. They did in fact provide evidence that by this staff report, I see you both shaking your head, so that's helpful to me. I'm not misreading and saying that they actually did provide it. The question isn't whether or not they can reproduce it or whether that methodology is something we can use over and over again. They've met the requirements of this application at this time. And that's one.
Yeah, I think that's the conclusion you can draw.
Okay.
And that's why we say those things in the staff report.
Right.
We're trying not to or state one side or the other.
Sure.
To be honest.
And I appreciate that. So there's a lot of good material in here. So my other question about that is, so we have a situation where they've complied with words writing, but what I'm not sure about is from the point of denial, did you do any of these methodology conclusions afterward, which is after the decision was made? We've now set up a scenario where we're trying to define or create a duplicatable methodology, which really is that code criteria amendment space. I feel like that if that time, and it's a timeline question, so I'm unclear where we're at with that. If we've, so hang on, let me find. So when we talk about that 71 times it was tested, right? When we talk about that, was that determined after the application was submitted and finalized? Because we have to comply with that application at the point of submission, right?
Yeah, I think the applicant submitted information on appeal, and we evaluated that information on appeal. It was a de novo hearing, new information, gives a second chance to evaluate it. I think, again, I want to restate what you've said. There's not a defined way in the code for determining these things, and the staff report acknowledges that. The question that we were trying to answer is not, is there a way to get 11 parcels? Not, is there a way to turn the template to encompass 11 parcels? But when you align that template to the maximum extent possible to the road, are 11 other parcels encompassed.
Right.
And so, yes, there is a way to turn the template to encompass 11 parcels, and we acknowledge that. Is that way aligned to the maximum extent possible? That's, I think that's, what the heart of the issue is. And our conclusion was that it doesn't, and because of that, we denied it. The planning commission could reach a different conclusion. You could look at that and say, well, absent a prescribed detailed method, any method that encompasses 11 parcels, we could accept. And you could apply discretion to determine whether or not that was to the maximum extent possible. And again, I think there was a question about precedent. I don't think it sets a precedent that the way the applicant's done it today is the way that everybody else has to do it in the future. We're trying to answer the question in a transparent way of how does, in this case, does the template align to the maximum extent possible? And when doing so, does it include 11 parcels and the other review criteria that apply to grant a dwelling? And that's kind of the question.
Okay, I have
You have one more?
a couple.
Okay.
Yep. Can I ask them?
Go ahead.
Okay, so the maps that we are using that align, well, so our GIS, that's probably a GIS question. that shows the road. Do we have a date on? So is Marys River Road a road district, first of all?
I do not know.
Okay,
It's not Mary's River Estates Road, it's actually a gravel road out.
right. So road districts being somebody else is maintaining it, not the county, right? And that's a question that I'm curious if we can get that answer. My next question is, what's the date of the map that we are using to determine? I mean, we are doing some pretty extensive mathematical gymnastics to try and figure this out. So let's just confirm that the map that we're using is a current map and not one that is shifted over time if it's a gravel road.
Yeah, I maintain the GIS data for the county.
Okay.
Tax lots are updated weekly, roads are updated as they need to be. The update process catches all the edits for all the employees in the county weekly. And so they are correct and updated as the latest edit from the employee that makes the edits in the data.
And did I hear you? I heard you. Did you say like roughly weekly?
Yeah.
So we think that that's a 2026.
If, yeah, it is accurate as of a week of whenever I pull the data.
Okay.
And I don't have a mic, but the Marys River Road in Benton County is a public road.
Okay.
It's officially recognized and maintained as a county road. However, while it functions as a public thoroughfare, the surrounding land ownership consists of a mix of private timberlands off of that road, Benton County tracts and state forest.
Okay, that helps answer that question. Thank you. So I guess my last, what I feel is an unresolved question is, if we accept an application at a certain date based on that methodology, we have not defined in our code, whatever, that's not a question, that's deliberation, excuse me. So my other question is, just to be clear, we do not define maximum extent possible, right? And is that, okay, so is that aligned with the maximum extent possible aligning to the road, or the maximum extent possible as in building housing, right?
It's the template aligned to the road.
Okay,
And that is in road bit.
that is in the code, meaning,
Maximum line to the nearest road
Or river.
and does that determine that we should take that whole stretch of road, right? So I have this property in the middle of it. Are we aligning to that piece of the road? Or are we aligning to the entire
I
road?
think it's one.
Doesn't it?
Oh yeah, it's just the template that's not.
It doesn't say how it's long, just the maximum.
Any other questions, Commissioner Bisco?
No, thank you.
Further? I'm gonna look around,
I'm gonna wait to the end.
wait till then. Commissioner Cash, I know you're online. Do you have any questions?
I don't at this time, thank you.
Okay, Commissioner Fulford.
We took those 250 little vectors, measured it all. In your methodology, did you do a mile, or did you do further, or just shorter? What was the actual?
I chose to use a process that would be reproducible in any parcel. And so what I did was I created a buffer from the centroid that was a half-mile radius, and then clipped the road there. So it's slightly more than a mile of the road itself.
Okay.
And so I think it's just shy of 6,000.
Okay. All right. Thank you.
All right, unless anybody has any other questions, we can always come back and ask additional questions at the end of the public hearing part. So we will move on then to the applicants, unless anybody else. Okay. Thank you. And then I would invite the applicant to join us at the table here and provide your presentation.
The engineer is going to also
That's fine. Yep.
be encompassed in the applicant portion, is that correct?
Yes.
So he's the proponent of the,
They can be part, they're part of the applicant. They can be up here as well.
well, I hired him.
But yeah, so yes, they can be up here with
Okay.
you as part of the presentation.
Please, go ahead.
And can we switch it so we're seeing not the presenter view, but the
Thank you. But there was one piece that was a little bit unclear to me. I'm hoping you can clarify, and it's on how you just, can we go back to the presentation that showed the 3 zones? I'm curious, and I think it's slide 3 with the 3 colors. The next one up, yeah. How did y'all choose those?
Good question. So I took the template, it's right at about a mile, so 5,280 feet from the centroid, and just simply divided it into 3.
Okay.
If you look, there is a stepwise process.
Yes, yeah, I saw that. Thank you.
Yeah, you can see the dash lines, construction lines, about in the very center, in the top.
It just didn't look like a third of the distance.
It's just the way the image is laid on there.
Okay.
Towards a promise.
Okay, no, I trust you. I didn't mean to.
But yeah, it's in thirds.
Okay. And it gets at this sort of broader question, right? Like if we're thinking about roadway design, we would use maybe like an inflection point or the line of sight. Like there's an infinite number of ways to slice and dice this problem. And I guess my question to Bob, or ultimately the question is, who decides? And and I don't think the precedence, which our other commissioner suggested, I don't think the precedence is this method in particular. It is, does the applicant get to decide what the method is when it's not specified in the code? And ultimately, I think that's the question.
We'll come back for final questions after that.
Okay, thanks. That was my primary question. Thank you.
Other questions for the applicant? Commissioner Lee.
So going back to the slide that shows the tangents, I think that's the one below there. How did you choose those 3 points?
Good question. So I looked at the thirds and I selected that. So I created a spline along Marys River Road. The spline was just a sketch inside of SolidWorks that follows the exact geometry that I imported from GIS. And I picked a point within that corridor, within that third that represented that orientation of the road in that region.
So I think this is the point where I think the county says you could have chosen any points.
Well, I think it's hard to.
Well, do the arrow.
Wait, hold on a second. Hold on a second, please. Commissioner Lee, did you want to finish your question or comment?
Yes. So choosing these tangents seems to be the crux of the technical aspect of this. And I agree with Desiree's comment. Who chooses? So I think that this is the key point to me. Who chose those tangents? Choose any number of tangents.
I'll let you respond.
Well, like I said, I could dig into the calculus of exact tangents on where the curvature is, but it's.
So did you choose tangents specifically so that you could get 11 parcels?
No, there are.
Did you see the method that he just outlined, how he did this?
Yes.
So do you see the tangents and do you see the angle of the road where those tangents are selected? Do you see how that's the angle of the road dominant in that section? So they weren't just selected freely. They were selected because he went through a very methodical process. Do you see how the angle of the road at that, we're not making up the angle of the road. The angle of the road exists. And that's the issue here is that no prescribed methodology is outlined anywhere. No one even says that any kind of math has to be used. And we use a very specific method, a very specific engineer analysis of how we orient this. And just because the county showed 8, 9, 10 parcels on their 3 methodologies doesn't mean that the 11th one isn't just as good as those methodology 1, 2, 3, 4, and the square also has 10. So they have shown various ways, and I showed you the corridor itself because you said, did I just willy-nilly choose? Did he just choose that in order to get these 11? Because that's kind of where I feel like this is all going back to someone created this just to qualify. Is that what I'm hearing? Is that you think that we just created those things just to qualify the 11?
I'm going to bring us back. I want to make sure we're getting all our questions answered and we can get So Commissioner Bolford.
I've got a follow-on question in the middle segment.
Please.
In the middle segment, Trace, that arrow, if you were to drag it down, that arrow is calculated based on that segment, middle segment, and it wouldn't be further down and to the right. It's kind of there because of all of the rest of the segment. Is that what you're saying?
Well, yeah, if you look at that, you're talking about tangent B, correct?
Yeah, the middle.
The middle.
Yeah,
So
the middle.
A is on top, B is in the middle, C is on the bottom.
Yeah.
So if you look at that particular tangent, you could probably move that tangent up and down, plus or minus several degrees. And it's going to slightly change that angle.
Sure.
As with all of them, right? I mean, you can.
Yeah, I think A and C sort of makes sense because the road is pretty straight.
Yeah,
The middle segment was.
That's why in slide 1, I kind of talked about there are almost infinite number of tangent points between those segments. So those are just 3 segments that I chose to represent from a tangent point.
And I guess that was the question. Was it you just kind of picking it, or did the software go, oh, this is the actual?
So this is really overlaid just to make it visual. The red in my report, I zoomed in on the tangents in SolidWorks and I did screenshots, and it's in the report.
Right.
The red color is just to make it visual for everybody.
Oh, okay. Gotcha.
Those are longer than they really.
So you're really within the software, and you were just kind of giving us some visual aids.
The arrows are not that. It's just the
arrows are a visual representation of the tangent. They're not that.
The actual tangent.
In the staff report, you zoom in. I zoomed in so that GIS could get the X and Y coordinates off of that. And so, like I said, I didn't have SolidWorks.
That helps. Thank you.
Thank you.
Other questions? Mr. Dixie, I saw your hand first.
Thank you. My question is just this. Thank you for your presentation. It's helpful to see how you came about this conclusion. And this is kind of maybe staff too, I'm asking, is the length of Marys River Road that you are using on your map here the same as what we have used at the county? Or is it longer? Because visually it looks longer and it may be just the same.
Okay, so
The size of
so everything is exactly to scale within the SolidWorks model that I created, and it was verified by staff, I believe. And my engineered drawing in the staff report is drawn to scale. Everything is dimension, tolerance, and everything's drawn to scale. I'm not sure if that's what you're asking.
So it was not exactly what I was asking, but it's helpful information.
The imagery that you see here is just for presentation,
Okay.
right?
So just let me go back to my question. So did we use, which maybe this is a staff question, I'm not sure. So what you use, so if we had, for example, if you used a longer segment of Marys River Road, you would have a different set of tangents. That's what I'm trying to ask. So are we using apples to apples here between your map and the county's map?
That's a good question. So you can see, you can't see this, but the road and distance from Centroid is exactly what the county used.
Okay.
So what he did was within the stretch of the rectangle that was created, the actual template. But I think you're asking a very pointed question, because when you were lining something to the maximum extent possible, why would you select 1 mile of the road? Well, because they told us to. We were looking initially at the whole corridor, right? We looked at the end of Marys River Road and the nearest intersection, just to make sure we were looking at a correct alignment. Bob asked me about this initially because someone along the way asked that question. Well, how did you arrive with this? Well, we were trying to show a similar approach to what was defined, not defined, but used methodology wise with the county, so that we could show that again, we were not trying to look at something completely different and say, this is why we qualify. No, we're looking at something
Okay, and that's
entirely
helpful.
the same.
So it sounds like we used essentially the same, so then it prompts the second question for me, which is that the full length of Marys River Road, or is there more to Marys River Road?
If we had shown that briefly in exhibit in the first presentation on Marys River Road corridor, I took the ArcGIS. I showed that, that was the one with the trees and the actual road that you were referring to. That was an imagery from the end of Marys River Road to the nearest intersection south of the parcel. And we drew a beeline. And that was what I was trying to speak to with respect to the road alignment on that first slide, is that if you look at our template, it's aligned with that, okay? The other ones are in kind of arbitrary angles off to the complete other orientation. So no, it's actually the
Slide 2.
Yeah, it's slide 2. And I know these are small, right? But I was trying to show you that all of these exist. And in this report, all of these exist.
Helpful.
So
that answers my question. Thank you.
Okay. So then I got Commissioner Wilson.
Oh, okay. Well, I'm looking, you have all of the various models up there. I'm kind of using this reasonable test for myself, and I'm thinking, okay, to the maximum extent possible. And I guess my question would be, if we looked at your, in Appendix C, in your appellate brief, you have your alignment of the 1 mile template. And then the county has in one of its, in the GIS linear directional mean, it has its 1 mile template, obviously, and I think it's the one that's down in the far left corner of your image there. If I'm thinking to the maximum extent possible to the road, I'm looking at those two images and I'm thinking, well, it's hard. How might you explain your template reaches to the maximum extent possible versus the county's figure 3 is, I guess.
So figure 3 is the GIS linear direction.
That's the one I'm looking at right now. Yeah.
So I think he could, Trace Hahn can also speak to this, but Marys River Road corridor, right? The question being the longer, the very top left, that is the actual Marys River Road, you know, from a point to another point further than the 1 mile.
Right, but my understanding, given the staff presentation, is that we can the template is 1 mile long and 1/4 mile wide, so we can only use the mile section of the template.
No, the template can only be 1 mile long, but aligning to the road to the maximum extent does not speak to the mile. It's the maximum, what is the actual?
Well, just to clarify real quick, so the template definition is a 1/4 mile wide by 1 mile long, which is 160 acres. Just want to clarify.
No, I understand that. I understand. So.
Okay, so I see what you're saying. They have developed a direction different than our direction. It's within the 1 mile range. Why is that?
That's well, my question is.
So one methodology.
I guess my question would be, how would you define and describe your template as being to the maximum extent possible following the road versus the county's? And I'm using the GIS linear. I know they use 3 different models, but yeah,
if I can
sorry.
Try to define, help summarize your question.
Sure.
Is you want to know how theirs would meet?
Well, no, I'm just asking. I think I'm asking them just to describe, if they can, how they feel they meet to the maximum extent possible definition.
Oh, okay.
Or descriptor.
Can we speak to that, both myself and?
Sure.
Sorry, I just got lost in what I was trying to say.
No, it's okay.
Look at the roadway itself, and at the top of the road, can you look at that? The top of the road, what direction is that going in? The top of the road outside of the grade template on our template.
And it's hard for, do you have this, is that page?
So,
yeah, I don't.
I'll just show you because I don't know why it's not on here. If you look at the road and what direction it's going in, look at that with reservation to this,
Right. No, I,
to this method. Now,
Right.
look at the road in the direction it's going at the lower end of the same template. And see how it's following that? That's that and the road
Okay.
lower at larger point.
Okay.
These two reasons.
I see what you're saying. And I think that does answer my question, because you are describing how you feel that your template meets that criteria. Okay.
I think you covered it pretty well.
Commissioner Struthers. Right now, obviously a pretty good discussion on both sides, a lot of methodology, lots of math, lots of engineering, and we've got a curvy road and we're trying to figure out, the right way to go. Right. And I think Commissioner Bisco said it well is, hey, were the rules established before or after they made their application? So kind of a tricky thing. Right now, I'm leaning on the approval of the appeal.
Approval, so you would approve the application or deny the application?
I would approve the application.
Commissioner Lee.
Thank you. So I agree with almost everything Ed said. However, I would vote to deny the appeal. I would say these mathematical questions are useful and very interesting, but remembering how Bob introduced this whole situation is the parcel soil classification defines it as highly productive forest resource area. And the template test criteria is intended to maintain long-term protection of the resource. It isn't to find 11 parcels so that to meet some arbitrary, it's all arbitrary. The number 11 is arbitrary. The number 3 houses is arbitrary. All of this is arbitrary, but it's a standard. And the standard needs to be replicable, and it needs to be defined by the county, the public, not the applicant. So I would say the staff has used standards that can be defined and are reproducible, and the applicant hasn't convinced me that their methods are exactly reproducible. In other words, I question the placement of those tangents, those 3 tangents, and the essentially statistical averaging of them. So I think that to be thorough, and the county went way out of its way to work with this applicant and find all kinds of different methodologies that were not contested, that were already established, and that they have done their job to deny this application in recognition that this is highly productive forest land, and that adding that the standard is to protect the forest land.
Commissioner Wilson.
It's a circumstance where I have to agree with Commissioner Lee. I think that the county used the county code and in developing the template test, which first had to be met by the fact that it is productive forest land. So the soils test, if I understood the way I read the staff report, is that was the first step, was to establish that it's productive forest land, which is an important resource for Oregon and for Benton County. And that once that was established, then they could do the template test, which was simply to find if, to the maximum extent possible, that template could be aligned with a road or a stream or river or waterway. In this case, it's a road. And that I think that they, in developing the 3 methods, and I don't want to repeat Commissioner Lee, but in developing those 3 methods that are in the code, and the number that, as Commissioner Lee has already said, seems arbitrary. Yes, 11 homes. That does seem strange, but it's 11 homes. It's 11 parcels. It's 3 dwellings within the code definition, and I think that that the staff arrived, I think, at the correct decision, and so I too also would lean towards affirming the staff's denial of the application.
Commissioner Biscuit.
Thank you, Pro Tem Chair Struthers. This is great, actually. So this shows the strength of this planning commission, and I really appreciate everybody's comments. My concern in this application and its denial, bringing up to this appeal process that we are in, is that we are literally trying to close the barn doors after the horses have been let out. We have established that at the time of the application, that Benton County Code criteria did not establish a process on how. I'll step back. In recognizing Commissioner Lee and Commissioner Wilson's points about forest land and whether or not it is productive forest land, I agree with that. And I understand that that code is designed to protect that. But that code also allows for this template process to occur, and meeting the requirements of 11 homes within that process allows for this dwelling to be granted as the code is written today. If that's something that we would like to see change, that's a future change. But at the time of the application, we have, yes, we've established this productivity of land, but we also have this exception to that section of the code. So when we went to apply that exception, and I'm hypothetically speaking, as we evaluated that exception, we have not defined maximum extent possible in the criteria, nor at the state level. We have not defined a process as to how we understand maximum extent possible, how we apply it to the mapping that we're using, the length of the road that we're required to use. We have not required a replicability of a process that we haven't defined, because we couldn't possibly do that if we didn't have the process defined in itself, nor the alignment of the maximum extent possible. So I am concerned that we're talking, so even in our.
So Commissioner Bisco, I just want to make sure we're somewhat, like, it's a quick. So
Sorry.
that way when we get
Yes.
to the notion, we can discuss our actual deliberations.
So page 6 of page 8, the template encloses 11 parcels at only 3, it says only 3 of the 71 orientations tested by the county, but it's still provided 3 examples of where we have that existing. And since we do not have a standard or a requirement or a process, I find that I am leaning towards, excuse me, thank you, by the way, I am leaning towards, make sure I get the words right, granting the appeal and approving the application. I don't see how we can stand on a indefensible space and say, well, we, after the fact, went and we figured out how maybe we should do this. And we just haven't established enough of this process to be legally defensible, I don't think, as a planning commission, and say that, well, yeah, sure, the code says, the code actually doesn't say.
Commissioner Toles.
Thanks, Commissioner Struthers. I'll keep my comments brief. I feel like the county has demonstrated a willingness to explore multiple methods, and the keystone for me is that they can be replicated. And as a first meeting I've been to, it's a little bit uneasy for me because I don't know what the precedence is in terms of what allowing applicants to define a policy, and that's the space that I'm uncomfortable with. That alone already makes me uncomfortable that the community, the applicants are defining the policy for us. And that's a place where I have, I guess, a broader question. Are there other examples where that has happened? And that's because that to me is the ultimate precedence. Is a community or the applicants defining the process for us? And if we have done that in the past, then that sets a precedence for these applicants to define a policy. And if that isn't the case, in my mind, then the good faith effort that the county has put forward to develop replicable and rigorous methods seems appropriate to me, and I would be inclined to deny the appeal. So that's not a non-answer, sorry. But is the question, in fact, I guess the county is there a precedence that applicants are defining policy and process?
Would you, I don't know if that's a really appropriate time to respond to that question.
I think when you have deliberations, you can ask that question of staff, and I'll be happy to respond to that then.
So I'm going to provide my quick 2 cents, and then we can find a motion that I'll start by saying I am leaning towards the approval of the applicant and the appeal, primarily along the same lines of Commissioner Bisco, that the language is not clear, and we've dealt with this on the other cases where some of our language is not clear and objective, and it's open to interpretation, and that is something down the road we'll have to fix. But in this case, a definition of maximum extent, you can move that around as much as you want. And do you define that as the total mileage of the road? Do you define how it aligned with the road? That's not what we're here to discuss right now. This is one of I believe this is our first case, or at least my first case of dealing with something like this. And so it's very interesting that we're dealing with this, but I would be more inclined, along with what Commissioner Bisco said, for tonight. And with that, I would be looking for a motion, and I see Commissioner Wilson with their hand.
So, Chair Pro Tem, I'm going to go ahead and make a motion that we deny planning file LU 26-015.
Is there a second?
I'll second.
So the motion at hand is to deny LU 26 LU 26-015 and uphold the staff's decision. Correct?
Yes.
Okay.
Yep.
Then we will move into deliberations on that motion itself. And who would like to speak to that motion? I guess Commissioner Wilson, since you made it, would you like to speak to it?
Sure. I think that having read the report and the appellant's brief on the template test, the staff report on the template test, I'm not certain that I don't feel as if the staff has essentially created after the fact, after the application was made, a particular test for the template. I think that they were using the template test as it was originally designed, and that they went out of their way in order to accommodate the applicant and looking at least a minimum of 3 different models around which that template test was conducted. After, of course, the determination that the forest lands met the criteria for having the template test conducted. And if I'm looking at the preponderance of the evidence and assuming that the staff is presenting that evidence in good faith, then I feel that it's at this point it would be our responsibility to affirm the staff report in denying a template test because it fails on the number of parcels. I don't know that it necessarily fails on the number of property or dwellings, but I think it's the number of parcels. So anyway,
okay.
Sure.
Others? Commissioner Fulford, and I think I felt Commissioner Lee.
Thank you. One of the things I was thinking about was, why do we have a template, right? It's to find other parcels that match our criteria, right? And the applicant did, right? And it wasn't, well, it is fully to protect the forest, right? But in protecting the forest, if you can put a 1 mile by a quarter mile template somewhere in the on the centroid, right? Then it is still protecting it, but it is able to find the 11. So I think the applicant is also working in good faith. And for me, looking at the different, I'll say, layouts of the template, the road to me looked like it was going like this, and the other ones were actually not aligned. And so I'm still in favor of proving the appeal. And I do think the applicant is working in good faith and not just spinning the dial until they find 11 parcels. So, additional comments.
Commissioner Lee.
Okay, I'd like to read the 2 different interpretations of the purpose of the template test. The template test criteria are intended to maintain long-term protection of commercial forest lands by ensuring that a new dwelling right authorization only occurs in areas already disturbed by existing patterns of development. So this protection is accomplished through the soil test and then this template test. So the template test. The other definition of the template test is the purpose of the template dwelling statute is to recognize areas where a pattern of parcels and existing developments already exists. The purpose of the template test is to provide a reasonable, replicable standard that can be used to show an area is already has a pattern of development. And one of the things we haven't discussed here are the locations of the homes. We're just looking at the road and the directions and the number of parcels. So I think that would be an interesting clarification to show how many of these parcels, how much of this area has already been developed with housing. In other words, the capacity for all of the conflicts that happen when there's ag and forestry right next to residential. That's the kind of issue that we're looking at, that we're trying to preserve an important resource and protect it and protect future homeowners from the conflicts of living within resource lands and the impacts of living within resource lands. So I think the purpose of the template is being lost in this conversation by just discussing numbers and math and models. The model was developed. The model has been used many times. When the county sends out its emails, frequently it does, it sends us the decisions, the notifications of decisions. And I have looked at them over the course of the years. There's a lot of template tests that have been dealt with administratively by the county in the past. Are we to say that those are all invalid because this issue has not been resolved in the past? The only reason this issue has come before us is because it's tantalizingly close to the arbitrary standard of 11. So I still believe that the county has done its job. It's gone away, it's bent over backwards to be accommodating. But this standard has to be, you have to consider the template test as being a reasonable response to the complications of each different parcel, each different scenario that comes along that requires this kind of decision making. And to say that the words aren't defined, I mean, we've been through this as a planning commission before. Words aren't defined. Well, that gives us as human beings the power to be involved in making rational decisions. Otherwise, why have a commission? We can just use AI to make the decision. We're here to make a reasonable decision. And we went through this so many times before where words in the code weren't defined. And we appreciated that because it gave us the power to make a decision. And in this case, I appreciate the power to make a decision. And I don't want to get lost in the math and the models. The idea is this is resource land, and the purpose of the template test criteria is intended to maintain long-term protection of commercial forest lands by ensuring that new dwelling rights only occur in areas already disturbed by existing patterns of development. Thank you.
Any other deliberations? Commissioner Vesco?
Yep. Again, I appreciate all the arguments here. I have still a number of concerns about what we're sitting with right here. I feel that, so I really struggle with, I appreciate that the county went to the extent of 71 different orientations tested, but I don't know how those were tested, right? We don't have a model that is required by code, and we are subject to, just like criteria, how we interpret that. It sounds like we have used models in the past. We don't have that information in this record to consider. I would have been interested in that had we had that, but we do not have that. Staff was able to reproduce this, which makes their modeling replicatable. I recognize that we have the forest lands that we are trying to protect, but I also see that in Marys River Road, that's not very far away from Philomath, that is a space of which we have historically had disturbed lands. As in, we've already got dwellings in that space. So that exists. What was also not answered, and maybe staff can answer this question, is whether or not, Commissioner Wilson, you brought up about the 1920s structure, perhaps. Do we know whether or not there had been a home previously within this 97 acres? I don't know that we had that actually answered. Is that able to be confirmed by any chance? on the 97 acres. So there's two things why I'm leaning into. Number one, we're talking about an area of which we already have dwellings that exist. And we have 11 of them that fits our code within a certain template model that is undefined, that was able to be reproduced by the county. I can't speak to whether or not that on the 97 acres itself that we have already disturbed those lands, that may have been helpful. But so I'm concerned that number one, staff went through and did these 71 orientations after the fact, it sounds like to me, right? After the decision making, it wasn't in our code. It's not established as a process. It's not established as a model. So we could bring in any applicant, not just the applicant here tonight, and say, well, here you go figure it out. I don't feel like an applicant should be coming to the county and saying we need to have GIS experts, mathematicians, and engineers to figure out what our methodologies are. They're simply not prescribed here. And I think that's part of where our challenge may be. To Commissioner Tullis's question, which I appreciated as well, was the precedent question, as I heard it. When we talk about should applicants be able, I'm paraphrasing, but should applicants be able to determine methodologies or determine interpretations? We all spent an awful lot of time reading a lot of information and testimony on a 33,000 page now record by the landfill that did a heck of a lot of interpreting of our language. So with respect to our commissioners that believe that this is a denial, my concern is more a legal one in that I don't feel that we have established a clear enough pathway to say, yes, this is the process we require. This is how we do not, I appreciate Commissioner's Lee, we do not interpret maximum extent possible, because that's another one of those spaces we can't. I don't think the state does either. So when we look at that, we're left to understand, excuse me a moment. Pardon me, from our record. But I don't think I could go back and say, yes, the applicant didn't do their job and the county did their job after the fact, after the applicant submitted their application. I don't think that I could look back at that in an appeal process and say that that's defensible, and that's my concern.
Commissioner Tullis, did you want to add anything before I add my comments?
Pardon me.
So this is an interesting one for me because I'm sitting here trying to help manage the meeting, but then also gather my own thoughts, which is always it's always a fun. So, but I do appreciate the conversation. As I've been sitting here and listening to you all think, I have to remind myself that this is a de novo hearing, meaning even though the planning official denied it, we as a planning commission get to review the whole application as a whole, including any new evidence. So sort of Commissioner Bisco's comment about the 71 tests, those are now part of the record because they were as part of the de novo process, at least from what I've heard. But I go back to the actual language of the applicant, the staff with decision. And I mean, the first part, at least what I understand, is they did approve or accept that they passed the criteria, the first part of the code. And what we're really talking about is the template test of, did we meet that? And when you think about the orientation of that template test, does it get oriented this way, or which way? I agree with Commissioner Bisco that our code is not clear on what that is. Other than, the maximum extent possible aligned with the road, looking at the language here. And so I think, I go to that the applicant has the burden of proof. They're the ones that have to prove that they've met our criteria. And based off the way our code is written, without any actual definition of what maximum extent possible, we can make that up here now, which we would then be making policy within our code, which we're really not allowed to do. But we could have a consensus around what that means. But so that's where I go. They did everything possible within their power to use that part of the code, which is where this agreement is. And so I feel like they have done the work to meet the burden of proof with how the code is currently written. And so I agree with Commissioner Bisco that from a legal definition and whether I'm sure the county could defend either or both of however we decide this. And so, but that's where I'm siding with the approval of the application, which would be a no vote on this motion itself.
Right.
Can I make one?
Yes.
Regardless of your decision, I don't believe that you're necessarily creating policy. The policy would be, created in its most purest sense by legislation through the Board of Commissioners. I think what you're doing is you're applying your judgment to a discretionary review criteria, and your different views, reasonable views could arise from that discussion.
Thank you. That's probably a better summary than what I have. Any other discussion on this motion itself? Commissioner Biscuit.
Excuse me. I do want to make just one, so something that the applicant presented to us here in this testimony was the fact that their model, which I feel like we're really constrained in how we interpret that model, but it was a reasonable interpretation of our code, right? So the word being reasonable in that the application, the template as it was applied in their example was done so by professional engineers. And it sounds like it was backed up with another professional engineer. It was a reasonable approach. ARC staff has also concluded they were able to reproduce it, that it was in fact one of 3 of the 71 presentations that met the requirements of our code. And so the word for me is reasonable in this space and how I consider my vote.
Is that true?
Commissioner Lee. Oh, excuse me, I'm sorry, but we can only discuss it with ourselves.
Yes.
I will our staff respond to the question.
Do you mind if I do that?
So Commissioner Lee, can you unmute your mic there and restate your question?
Your question, please.
So my question is, was the applicant's model one of the 73 that was provided in that last analysis or in that analysis?
It was, and when we say that we were able to reproduce their results, we were able to reproduce their results given those 3 specific tangents.
Exactly.
We weren't able to pick those tangents based on what we were given, the locations where they were. And so to get around that is why I tested the 71 different orientations. It's as if I picked a bunch of different points that were tangents and then summed them and then did that.
I'm going to stop there so that we can get back to our discussion. So Commissioner Lee.
So that's my major concern is those 3 tangents are what's not reproducible. The decision about, and those 3 tangents are the basis of the applicant's model. And that's why the county says that their method is not reproducible. I mean, it's reproducible, but anybody could reproduce it. It's just one of many potential. So essentially this whole argument is somebody's got arbitrary numbers and somebody else has got all arbitrary numbers too. It's all about arbitrary numbers. And the county has standards and precedents, and their alternatives were established and uncontested methods. So that's my point. The applicant's choice of a model based on 3 tangents that were chosen in an arbitrary way is no more or less arbitrary than the choice of 11 parcels and 3 homes, or the choice of 1 mile and a quarter mile. It's all arbitrary numbers. But there is a standard. There is an established standard. And I repeat, if the standard is in question here, it's in question in all the past uses of the template test. And I don't think that would be fair either.
Commissioner Fulford?
Some additional comments on the methodology that the various folks, because you're right, lots of different tangents, lots of different things. But I think part of it is maybe the software that one group was using compared to the approach the other group was using. So one group did three three segments, right, and tried to find a tangent, but the software gave them the tangent numbers versus the county using different software. So even though the county could get to there, maybe if they had the same software, they didn't and couldn't because of the software that they had. So I think it might be arbitrary, but I think it's also constrained by the tool set that their various teams are using.
Are we ready to take a vote? All right, we will do a roll call vote then. I can call the roll, or would someone want to?
Do you want to just remind people what the
Motion.
Yeah. So the motion is, the motion is to deny the appeal of LU-26-015.
Denying the appeal would,
So a yes vote would deny the appeal, a no vote would disagree with that statement, and then we would continue discussion. Because we have to have
okay.
A no vote cannot be a decision.
Right.
Like, if
That's
the
correct.
majority have the no,
That's
it
correct.
would not be a decision. It would just be denying that motion. We'd have to do another
Absolutely.
motion.
That's the
So
motion.
yes vote would deny the application.
And no vote would
would turn down that motion.
the motion would die.
Would die, and we need a new one.
No, wait, no, you said application.
Okay. Let me start over. To me, so a yes vote would deny the application.
Deny
The appeal.
Appeal. Excuse me. Thank you. Deny the appeal.
Deny the appeal.
A no
Which
vote.
would
Affirm the county's
the
decision.
county's decision to deny the application.
Yes.
A yes vote would deny the appeal and affirm the county's decision to deny the application. Okay.
Right. And a no vote would turn down that motion, and we need a new one. Right. Okay. Is that as clear as mud?
and it might be helpful if you kind of want to be certain, you could say, you know, for example, the motion is to deny the appeal, right? So you could say, I'm voting for the motion to deny the appeal.
Okay.
So, or
Okay.
I think I
vote for my
Yeah, right.
That might be complicating things.
You can rephrase the motion. We actually need to vote on it, or we have to withdraw it.
So the vote is, a yes vote is to deny the application.
The appeal.
The appeal.
Oh my God,
man.
don't do that.
Maybe withdraw.
Okay.
Maybe
Okay,
withdraw.
no. So a yes vote is to deny the appeal, which would also deny the application.
A yes vote is to deny the appeal.
Yep.
And would
And
deny the
Yes.
application. That's helpful.
Okay.
Because they are one. And no vote would then, we would need to have a new motion.
The motion would die on.
Yes.
Yeah. It would.
A yes vote denies the appeal and the application. A no vote, we would continue our discussion.
Got it.
Is that better? Okay.
More clear.
I'm sorry, ask a couple more questions.
Yep.
It seems like I need to get my babysitter to stick around longer. If we have a tie vote, what happens?
Can we cross that bridge when we get there?
Yeah, we have to get there.
Okay.
It'll be great.
So I will do the roll call vote unless somebody on staff is going to do it. Okay. I will then start with Commissioner Lee.
I vote to deny the appeal.
Okay. Commissioner Fulford.
I vote to approve the appeal.
So you be a no vote. So that's from that. Commissioner Wilson.
I'm voting yes on my motion to deny the appeal.
Commissioner Bisco.
I'm voting to no, so I am approving the appeal.
And Commissioner Tolley.
I'm voting yes to deny the appeal.
And I will vote no. So we did cross the bridge. So we do have a tie. So I'm going to ask that we take a 5-minute recess while I consult our bylaws and check with staff on next steps. So I'm calling for a 5-minute recess, and we will be back at roughly 8:15. Thank you. And
Desiree, welcome, by the way.
welcome. Yeah, welcome. This always happens with new commissioners. It's always something like this. Okay.
Yeah, but at some point, like, does the meeting, I have to get my kid to bed, so.
He'll check us out. I forget, isn't this still a no vote? Or excuse me.
That's what I'm double checking.
That's what he's double checking.
Is
We have
the
to
rules
see
on this.
on a tie, we've never had a tie.
This is an odd one for me.
So it's.
We are being recorded again, and I see the little green mic there saying that it hears us talking, so that's good.
It's my background is business.
So we currently have
That merged together.
on the table the motion, and on a 3-3 tie, that motion does fail. So the motion has failed. After reviewing our bylaws, I did verify that as chair tonight, I am allowed to vote, because some rules do not allow chairs to vote. Our bylaws state that the only thing that the chair cannot do during a meeting specific to voting is make a motion and second it.
Right.
So all commissioners, including the chair, get a vote. So that option is not an option for the tonight. We have at least 2 routes we can go. We can put another motion forward, and try to convince each other whether that motion should pass or fail. The other motion, since we are deadlocked, and from what I feel tonight, is not going to change unless we want to spend another hour or two discussing this, is we could close the public record tonight and recess this decision to a future meeting where we would have the other commissioners, once they've had a chance to review this meeting, the deliberations, and have additional bodies here to vote. So I would put it to the commission.
Do we need a motion on the continuance?
It wouldn't be a continuance.
The hearing,
Or are we actually keep?
has been closed because you're in deliberation.
Yeah.
Yes.
So the public hearing portion has been closed, you're in deliberations. And so I think your 2 options are to, well, maybe at this point, the hearing is closed. I think your only option is to continue deliberating on a future.
So it'd be a motion to table this decision to a future meeting.
And I would suggest that we make a date certain meeting so anybody from the public knows what to expect. We're not noticing things.
So,
Can you make the date in the motion?
Yes.
Yeah.
So it would be the next planning commission.
And do we use the?
So that's one option. The other option is we put a motion forward on the decision and we continue debating that issue and trying to convince each other.
That's correct. You could put a motion, another motion out.
So I saw Commissioner Wilson's hand.
My only question is, should we use our typical first and third Tuesday calendar for that? Okay, and you're affirming my question.
And
Me, I am not affirming your question. I have a motion.
And then so we're going to go to Commissioner Biscuit.
Very good. Thank you. Pro Tem Chair Struthers. I make a motion that we continue this deliberation to include the 3 commissioners that were participating prior to doesn't have to be, but we had 3 commissioners also participating. To allow them the opportunity to weigh in on this discussion. My motion is to your point, to continue this deliberation, on August 4th, which is our next, can we do that at that's our next planning commission meeting?
So the motion before is to table discussion on LU 20-26-015 to August 4th, 2026. Is there a second?
I'll second.
I have a question.
Okay, question?
Do we re-engage deliberation at that meeting or do we just vote?
We would, so since there is no other motion on the table, we would have to put a motion forward. And then we would re-engage deliberation on that motion to either approve or deny. Commissioner Wilson.
Oh, I was only going to say that night is a conflict. I have city council responsibilities. That shouldn't prejudice your decision about or voting for the meeting on the August 4th date, but I'm just stating that for the record.
Is there any reason we cannot push this out to 2 weeks from then, which would be the 17th?
I guess maybe what I would do is I'd ask the applicants, in this case, if they would grant an extension to the 150-day decision-making timeline. So maybe 45 days. That just would give us I don't know if you understand what that means, but we have an obligation to make decisions within a certain period of time. If not, then if we're gonna be pushing up against that, then I request an extension from the applicant. And so, that would give us a chance to come back and deliberate, in, either August 4th or the second meeting of August.
17th or 4th. No,
Is it the
4th
18th?
plus 14,
It'd be
18, right?
So I guess first, so I'm gonna put a pin in this real quick. Bobby, you've asked a question of the applicant about extending by, sorry, how many days?
I said 45 days.
So I'm gonna look to the applicant. Are you okay with us extending our timeline, the timeline? This
For the August 4th date,
okay.
if we can get enough people to make a vote.
Okay.
We can,
If we can't, then we don't have a choice.
yeah, I don't, sounds like there's a willingness from the applicant to, if necessary, extend that decision-making timeline by the amount needed to get to a.
So what I will say is for now, that I want to move this forward is we'll say August 4th in the motion.
But Mike, sorry.
Yep.
I just add just to insert something to think about. If Commissioner Wilson is not here, we'll need to make sure that everybody else who does participate has listened to the public hearing,
right,
and understands it, and have
Right.
their chance to fully engage. So if that's fine. They can they can watch the hearing, and then come to deliberations and make a statement that they're fully.
So what I was going to add, I was going to add a friendly change to this to say that we are tabling the discussion on LU 26015 deliberations. Thank you.
You're welcome.
Deliberations of LU-26.015 to August 4th, unless quorum can't be met on August 4th. We would then extend it to August 18th, and staff will verify quorum between now and then. Would that be an acceptable change?
It's acceptable to me. The question is whether or not they're willing to extend that date extension that we need.
Well, question is, so maybe John can't be here and only one of the other three can be here. That's kind of.
Yeah. Let's just, okay, how about we keep it to August 4th and we'll cross the bridge later. So we'll just keep the motion to table to August 4th and let's vote on that.
Yeah, if worst case is you come to August 4th and you meet and say, we don't have a quorum, we're pushing this out again.
Yes.
Right.
Okay.
And the record, so just for clarification, we can review this record in this period of time also, correct?
That's correct.
The record added.
Yeah.
As it, correct.
Right.
We're not adding anything to
No,
it.
right.
so-
No new evidence
We
because
can
the
go
record's
back and listen
closed.
to today's, your staff report, for example, discussions, and Russell, thank you. And then
can
the
go back and
applicant
watch
as
the
well.
video.
Yep.
Right.
Okay.
Okay. So the motion at hand is to table this deliberations on LU-26-014 to August 4th, 2026. And I'll say 6 p.m. in this room that we are in currently. All in favor in that motion say aye.
Aye.
All those opposed say no. Okay, those deliberations have been tabled to August 4th. Moving on to the next item in our agenda is the planning commissioner staff updates. Bob, do you have any updates from
You may notice our planning officials return. Happy to have Petra back. It is her department. With her return, we're picking up on some of the code amendment stuff that we've talked about. There's that.
statute, but because we have not really had that opportunity to engage, people aren't sure how, the questions I get is how do we communicate? Where do we give feedback? And that's a broken link that we've been talking about for, this is the 4th year. So I'm hoping that we can bring that to some conversation as you juggle everything else that you're juggling. But thank you for considering. That's all.
Yeah, great question.